Governing Texas, Chapter 13, Part 2. Reform of marijuana laws. There have recently been dramatic changes in marijuana law enforcement in Texas. However, in 2007, the Texas legislature gave police the option to cite and then release a person arrested for possession of less than 4 ounces of marijuana. The citation is much like a traffic ticket, where the person would have to appear in court and would be subject to criminal punishment, but would not be arrested, booked, or put in jail until bail is paid. For years, this option was rarely used by police departments, but recently several counties have begun to use the cite and release since it saves police time and costs to local government associated with keeping someone in jail. Increasingly, there is also the view that jailing a person for small amounts of marijuana is an overly harsh punishment. Still, the most dramatic change in low-level marijuana law enforcement appears to have been unanticipated. In the 2019 legislative session, hemp was legalized in Texas. Most of the law focused on the production of hemp and agricultural regulations, but the law also narrowed the definition of marijuana to cannabis containing more than 0.3% of tetracannabinol, the THC. Anything less than 0.3% of THC was legal hemp. The problem was that the public laboratories used by law enforcement could only test for the presence of THC, not for how much THC was present. As a result, prosecutors around the state began dropping hundreds of low-level marijuana cases. Some police departments have relied on private laboratories that have the equipment to measure the amount of THC, but it costs local governments hundreds of dollars per test to use these private laboratories. The effect of the hemp law on marijuana prosecutions has been remarkable, dropping the number of low-level marijuana cases filed by more than half. Here's the vocabulary words for the next section. Crimes in Texas district attorneys. Ordinarily, when we think of the criminal justice system, we think of the police who make arrests and the courts that adjudicate those cases. The most important factors in the Texas criminal justice system, however, are probably the prosecuting attorneys. Some counties have an elected county attorney whose office represents the state of misdemeanor criminal cases. The county attorney usually provides legal advice to the county commissioner as well. Although generally the county attorney does not represent the county in civil cases, counties with elected county attorneys also have elected district attorneys who represent the state in felony cases. In some counties have merged the offices of county and district attorney into an office that represents the state in both misdemeanor and felony cases and is often called the Office of the Criminal District Attorney. In urban counties in Texas, the Office of the District Attorney is huge, encompassing several hundred lawyers, investigators, and support staff. In 2020, the Harris County District Attorney's Office employed 329 prosecutors and a total of about 700 employees. In many rural counties, the District Attorney's Office includes only 1 or 2 lawyers. The head of every district attorney's office in Texas is an elected officer who runs under a party label for a 4-year term. As the chief prosecuting officers of a county or district, district attorneys have traditionally campaigned as tough on crime, and they brag about high conviction rates. It has generally been the case that if they appear to be too lenient of their conviction rates are too low, political opponents will emerge who will accuse them of not doing their job appropriately. In the urban counties in Texas, however, a new type of district attorney has been emerging who places a great emphasis on prosecuting violent crimes than on minor ones, and who cultivates an image as a reformer. That new style has been especially notable in the larger urban counties where district attorneys often support programs to examine claims of actual innocence by persons convicted of crimes and who seek to minimize jail or requiring money bail for persons accused of minor crimes. While the number of or reform district attorneys is small, their jurisdiction are generally among the state's larger counties, and so they have great influence on criminal justice prosecutions in the state. The district attorney has prosecutorial discretion, which means the power to charge or not charge a person with a crime, even when a case is presented before a grand jury. To determine if a criminal indictment should be issued, the grand jury is dependent on the prosecutor to present the evidence that may lead to an indictment, and a prosecutor has great discretion in choosing both whether to go before a grand jury and whether to accept or not to accept the decision of a particular grand jury. Here's the vocabulary words for the next section. And I'll kind of do a close-up of this. Crime and criminal defense. Persons accused of crime may represent themselves or may retain a criminal defense lawyer to represent them. Since the famous Supreme Court case Gideon versus Wainwright, 1963, persons too poor to hire a lawyer have had a constitutional right to have an attorney appointed to represent them in serious cases. As mentioned in Chapter 9, in Texas, that representation is generally provided by assigned counsel. That is, the judge will appoint a lawyer to represent people who cannot afford one. However, in some counties, in at least some types of cases, such people will be represented by a public defender, a lawyer who is paid a salary by the government to represent indigent defendants. With assigned counsel, usually judges appoint a private attorney on a case-by-case basis for a fee that varies according to the county and the legal service performed. One concern with this system is that the fee may be so small that the assigned attorneys do not do an adequate job in representing their clients. The issue of the quality of representation provided by indigents in Texas is an important one because large numbers of cases are tried and substantial amounts of money are spent in providing this representation. Table 13.2 specifies the 2018 cost of indigent defense in the state and the number of cases involving people whose lawyers are paid by the state. Some of the fees counties pay for assigned counsel seem remarkably inadequate. As example, Bexar County pays appointed counsel $75 an hour for trial work involving a state jail felony, $100 an hour for a second-degree felony, and $125 for a first-degree felony. Harris County pays $300 a day for trial work in a state jail felony, $400 a day for a second-degree felony, and $500 a day for a first-degree felony. The joint Jack and Wise County Judicial District pays lawyers $400 for each half-day of trial work for felonies and $250 for each half-day of trial work for misdemeanors to a maximum of $1,000. Public defenders are far rarer in Texas than are assigned counsel. However, statewide public defender program is available for capital cases and serves participating small and mid-sized counties. There are a small number of other public defenders offices in Texas, and they are regional or county-wide in scope. Some of those have specialized caseloads such as mentally ill defendants, rural areas appeals, or juvenile defendants. The public defender program for capital cases has been evaluated by comparing it with assigned counsel in capital cases, and several interesting findings have emerged from the study. For one thing, in rural areas of the state, few lawyers are qualified to handle capital cases. In an area Texas spanning over 80,000 square miles, for example, only 13 private lawyers are qualified for these cases. For such an area, death penalty specialists, who are public defenders, are particularly useful, and they also have the necessary support team that would be difficult to organize in more rural and isolated parts of the state. For many smaller counties, the cost of the death penalty cases is prohibitive. Defense costs alone often exceed $100,000. Participating in a public defender program with a death penalty specialist can greatly reduce costs for these counties. The public defender was also more likely than assigned counsel to avoid a death penalty and to get better dispositions for their clients overall. Death penalty work is very specialized and complex, but the success of a public defender programs over assigned counsel in such cases suggests that an expansion of public defender programs in other areas may be beneficial to indigent defendants. Here's the indigent defense in Texas in 2018. Crime corrections and the Texas prison system. It has long been claimed that Texas does things in a big way, and that is certainly true of its level of crime and the way it deals with criminals. As of August 31st, 2018, there were 145,019 offenders incarcerated in the state's prisons, state jails, and substance abuse facilities. These numbers exclude those incarcerated in municipal and county facilities. The average cost per day for each bed in the state correctional facilities was about $53. It cost about 26 times more to imprison someone than to place that person on probation, and about 18 times more to keep him or her in prison than on parole. History of the prison system. Shortly after Texas joined the Union, construction was authorized for state penitentiary in Huntsville. The 225-cell facility opened in 1849. It confined prisoners in single cells at night and congregated them during the day to work in silence. From 1870 to 1883, the entire prison system was leased to private contractors who used the labor of inmates in exchange for providing maintenance and prisoner supervision. After 1883, convicts were leased to railroads, planters, and others who provided the prisoners with food and clothing and paid a stipend to the state. The leasing arrangements were abandoned in 1910 as a result of scandals and abuses of the system. Under the new state-run system, however, abuses continued. In 1924, an investigation found inadequate care and brutal treatment of prisoners, as well as insufficient management. That investigation led to the creation of the State Prison Board, which supervised the work of General Prison Manager. Still, abuses continued, and by the mid-1940s, the Texas prison system was considered one of the worst in the nation. In 1974, the Joint Committee on Prison Reform submitted findings to the legislature that found serious fault with numerous aspects of the system's operation. From inmates' living and working conditions to their classification, and from medical care to staff training, still no significant reforms were made. The event that had the most dramatic effect on the system's operation in modern times was a federal court case in Ruiz versus Estelle. Lawsuits filed by prisoners are nothing. It does this. Here's the who is in prison, Texas. Is nothing new. During the tenure of W.J. Estelle Jr., the prison director from 1973 to 1983, and the defendant in the Ruiz case, prison filed 19,696 cases in the federal courts in Texas, a caseload amounting to about 20% of the federal court docket in Texas during that period. However, the Ruiz case was exceptional, a class action suit on behalf of the inmates that began in 1972. It focused on issues of crowding in the system, security and supervision, healthcare discipline, and access to the courts. In 1980, a federal court concluded that inmates' constitutionally guaranteed rights had been violated. Texas joined several other states in having its prison system declared unconstitutional. The result was the appointment by the court of a special master, a court officer, to oversee the systems to eliminate constitutional violations such as overcrowding, improper supervision, and improper care of inmates. This massive reform had to be imposed by the federal courts because the state seemed unwilling or unable to reform its own prison system. Federal court supervision of the system ended in 2002. For a long time, many Texas government resisted federal court supervision of the prison system, arguing, for example, that Ruiz's decision amounted to judicial activism and interfered with the rights of the state. To reduce the overcrowding in state prisons, to comply with Ruiz, and the state encouraged the early release of prisoners, some of whom then committed more crimes. Ruiz did, however, help turn the criminal justice system into a major public policy issue in Texas. The prison system today. The Texas prison system is operated by Texas Department of Criminal Justice. This agency is run by a nine-member board appointed by the governor and members who serve staggered 6-year terms. The board hires an executive director to lead the sprawling agency, and it is responsible for developing the rules and regulations that govern the entire state prison system. Since 1993, the Department of Criminal Justice is responsible not only for the massive prison system in Texas, where convicted felons are incarcerated, but also for the much smaller state jail system. State jails are minimum security facilities, and they hold low-level drug and property crime offenders who are sentenced to serve 180 days to 2 years. Unlike county jails, no one in the state jail system is awaiting trial. They have all been convicted and are serving a sentence. The Department of Criminal Justice also runs a small program called Substance Abuse Felony Punishment Facilities, SAFPF, which provides assistance to offenders who need treatment for substance abuse problems. Offenders may be sentenced to this program by a judge, or the Board of Pardons and Paroles may require substance abuse services as a condition of parole. Typically, offenders receive a 6-month in-prison treatment program, as much as 3 months of additional treatment in a residential treatment facility, 6 to 9 months of outpatient treatment, and up to 12 months of support groups and supervision. In the wake of estimates in 2007 that Texas would need 17,000 new prison beds, costing $1 billion by 2012, the Texas legislature increased the capacity of prison alternatives such as drug treatment and halfway homes, much cheaper alternative to prison. Until 2007, when the Texas legislature began to seriously address alternatives to imprisonment, the state government had significantly increased the incarceration of offenders by building more prisons, especially in the early 1990s. In 2011, however, for the first time in Texas history, the state actually closed a prison. The century-old Central Unit in Sugar Land. After that, 7 other prisons closed, making a total of 8 prison closings in a 6-year period. From 1976 to 1990, The rate of property crime in Texas rose 38%, and the rate of violent crime rose 113%. Since prisons expansions in this period did not keep up with these increases, generous early release policies were used to make room for newly convicted inmates. With prison expansion, however, early release policies were reduced. In 1990, for example, 38,000 prisoners were given early release. In 1997, with a much larger population, only 28,000 were. The steady lengthening of sentences is shown in Figure 13.1. In 1994, prisoners on average were released after serving one-third of their sentences. In 2018, prisoners were serving 61% of their sentences before being released. Inmates at state jails served an average of 99.5% of their sentences. As shown in Figure 13.2, the Texas prison population reached its peak in 2000 and then dropped off. In 1990, at the time of Rua's case, there were fewer than 30,000 inmates in the state. By the early 2000s, the number had jumped to over 150,000, then dropped off to 134,152 by 2018. Here's the graph. Let's see if I can open it. There we go. Okay. Sorry about that, guys. Here's Figure 13.2. So you can read that. For much of the 1990s, the rates of violent and property crime in Texas were especially high. By the mid-1990s, however, those rates had dropped. While some observers argued that the drop was due to increased incarceration of offenders, there may also be other causes such as demographic changes. Of course, changes in laws and treatment practices also affect the crime rate and the incarceration rate. Long sentences for habitual criminals, for example, are relatively new, as are long sentences for the use of a firearm in the commission of a crime. The number of prison inmates per 100,000 citizens of the total population in Texas in 2018 was 549. Only 5 states, including Louisiana, with an astounding incarceration rate of 695 per 100,000. Beat the Texas per capita rate. See Texas and Nation graphic. Texas had 12.7% of the nation's total state prison population in 2018, and no other state had more inmates in its prison system than Texas. Nevertheless, the state ranked high in crime rates. Texas ranked 15 among the states in violent crimes per 100,000 persons. As Figure 13.3 shows, Texas imprisons mostly violent offenders. 2018, 57% of Texas prison inmates had been convicted of violent offenses, 13% of property offenses, and 17% of drug offenses. It is especially difficult for felons to gain legitimate employment after their release. So much so that the federal government offers a large tax credit to employers who give jobs to people who have served a felony sentence. This difficulty makes it more likely that former prisoners will commit further crimes. Another problem is that average sentence in a Texas prison is 18.5 years. After such a substantial time in prison, it is hard to readjust to life in the free world, and support structure such as family members have often died or removed the inmate from their lives. Still, another problem is that the average educational achievement of an inmate in Texas prison is only 8.43 years. Finally, frequent drug and alcohol addiction among felons make employment difficult and encourages criminal behavior. The problem of addiction is recognized during Governor Ann Richards' administration. Drug and alcohol treatment efforts begun at that time have continued and expanded. The death penalty. In 1835, when Texas was administered by Stephen F. Austin, the first death penalty was imposed of Joseph Clayton, who was hanged for murder. In those early years, hangings were public affairs where crowds would gather to watch the execution. It was not until 1923 that public executions were outlawed, hangings were changed to electrocution, and the state rather than the county became responsible for carrying out the sentence. Electrocution was believed to be a more humane and civilized means of execution than hanging, although the humanities of either method was highly questionable. Between 1924, when the first Texas electrocution occurred, and 1964, when it ended, 361 people were electrocuted in the state. After the Supreme Court required the states to revise their capital punishment laws, Texas reinstated the death penalty in 1974, and in 1977 switched to lethal injection as its execution method. In 1992, Texas executed its first inmate by lethal injection. Although lethal injection was considered a humane execution method, it has since been criticized for being inhumane. Today, Texas is one of 31 states that have the death penalty. Of the 20 states and the District of Columbia that do not impose the death penalty, 5 have been banned it since 2010. As of October 1st, 2019, there were 2,639 people on death row. Throughout the nation, although over 60% of them are in 5 states. California with 727, Florida with 348, Texas with 219, Alabama with 177, and Pennsylvania with 152. In Texas, one is subject to the death penalty for the murder of a public safety officer, fireman, or correctional employee. Murder during commission of a kidnapping, burglary, robbery, aggravated rape or arson, murder for hire, multiple murders, murder during a prison escape, murder by a prison inmate serving a life sentence, or murder of a child under the age of 6. Texas executed 570 people from 1976 through January 15, 2020. As figure 13.4 shows, though Texas has led the nation in the number of executions since the death penalty was reinstated by the Supreme Court, the imposition of the death penalty has declined in Texas and other states. National polling data show an increase in opposition to the death penalty, from 25% in October 2002 to 42% in October 2019. That 371 Texas inmates have been exonerated from 1989 through December of 2019, and that 11 Texas death row inmates have been exonerated during that time period, has perhaps contributed to reducing the number of executions in Texas. More important is that the death penalty cases have become more expensive and time-consuming for the state. A life without parole sentence is far less costly, while ensuring that the defendant will not pose a future danger to the public. Political scientists Paul Brace and Brent Boya found that judges tend to affirm death penalty sentences in states where judges are elected and where there is a strong public support for the death penalty. Texas judges are elected, and polls show much stronger public support in the Texas death Texas for the death penalty than in the nation as a whole. One 2018 poll, for example, showed that 65% of Texas voters either somewhat or strongly supported the death penalty, and that only 25% were opposed. Here's the graph. And here's this, should you wish to read this. A stay on death row can be a lengthy one, even in Texas. In Texas, the average time spent on death row prior to execution was 10.87 years. Sorry about that. Although the time varied considerably, one inmate waived his appeals and spent only 252 days. On the other hand, David Lee Powell spent 31 years on death row before execution in 2010. One of the issues involving the death penalty is whether all offenders are treated fairly and equally. Racial and ethnic minorities, especially African Americans, are disproportionately represented on death row. As of January 31st, 2020, 94 death row inmates were African Americans, 57 were Latino, 57 were white, and 6 were classified as other. Although African Americans constituted only about 13% of Texas population, in 2019, 36% of those executed from December 7, 1982 to January 16, 2020 have been African Americans. Of the 568 persons executed from December 7, 1982 to January 16, 2020, 250 were white, 206 African Americans, 108 Latinos, and 4 members of other racial and ethnic groups. A bias may exist in the criminal justice system that makes people of color disproportionately subject to the death penalty. Although the counter argument is that the murder rate is higher among people of color, when the bias issue was presented to the U.S. Supreme Court, the court refused to strike down the death penalty on the basis of statistical generalizations, essentially saying that there had to be evidence of racial bias in the specific case presented to the court. The Texas Board of Pardons and Paroles votes on clemency for death row inmates. The board was generally created as a remedy for possible corruption and clemency granted by the governor. Prior to 1936, the governor essentially had eliminated power to grant clemency, a power often abused, especially by Governor Miriam Ferguson, who granted 4,000 requests for commutations of sentences in 1922 alone. It was widely believed that payments were made for many of these acts of executive clemency. In reaction, a constitutional amendment was passed in 1936 that charged the board with giving the governor recommendations on clemency. Without such recommendations, the governor can grant only a single 30-day reprieve. No other state limits the power of the governor in this way. In 2007, the board recommended commutations of Kenneth Foster's sentence to be executed only 7 hours before Foster was scheduled to die. Governor Rick Perry commuted Foster's sentence to life imprisonment about 1 hour later. Foster's much publicized case seemed to challenge 2 aspects of the death penalty in Texas. One, Foster had been tried simultaneously with the other defendants in his robbery and murder case rather than in a separate trial. And 2, he was the getaway driver in the crime and not the actual shooter. Simultaneous trials with other defendants in murder cases can be a huge disadvantage for a defendant like Foster, who was not the shooter, but was nevertheless tried with the shooter. Foster was tried in this way because Texas has the law of parties a person involved in a crime that leads to a murder is guilty of murder, even though that person is not actually the person who committed the murder. Self-defense and concealed open carry of handguns. In any examination of crime in Texas, that enormous concern Texans have with self-defense cannot be ignored. One of the most controversial issues in the state over the past few years has concerned concealed and open carry of handguns. Advocates of concealed and open carry argue that the U.S. Constitution's Second Amendment provides them with a constitutional right to bear arms. Article 1, Section 28 of the Texas Constitution provides a similar right with the caveat that carrying arms is subject to state regulation, and it states, every citizen shall have the right to keep and bear arms in lawful defense of himself or the state, but the legislator shall have the power by law to regulate the wearing of arms with a view to prevent crime. To a large degree, the wording in the Texas Constitution sums up the long-standing political debate over carrying firearms. Does it provide protection against crime, or does it lead to crime? In 1871, during the Reconstruction, Texas passed legislation against both concealed and open carry. That law was not substantially changed until 1995. The legislature passed its first bill legalizing concealed carry, which was signed by Governor George W. Bush in fulfillment of a campaign promise. In the 2011 legislative session, concealed carry of handguns in college campuses became a major issue, and there clearly were enough votes to pass a bill allowing it, but it failed because of a parliamentary challenge. At the same time, legislation was passed and signed into law that prohibited employers from banning guns secured in employees' vehicles in company-owned parking lots. In the 2015 legislative session, a bill allowing open carry of firearms passed despite concern that it would increase violence and lead to the intimidation of others. The handgun must be in a hip or a shoulder holster, but no longer needs to be concealed. A concealed handgun is still required, however, which means the license holder must be 21, pass a criminal and psychological record check, and undergo classroom and shooting training. In 2015, campus carry was also passed, which allowed licensed gun holders to conceal carry on parts of Texas public universities. Campus carry has been one of the most controversial aspects of Texas handgun legislation. It required public universities to allow concealed handgun license holders to carry, except in some restricted locations on their campuses. Some faculty, especially at the University of Texas, Austin, expressed concern that campus carry would lead to campus violence. At least one senior professor resigned over the policy, and 3 professors filed a lawsuit in an unsuccessful effort to stop it. To date, however, campus carry, concealed carry, and open carry have not led to the violence their opponents predicted. Open carry has proven rare in the state's urban centers, and the numbers of students who can carry handguns on campus is limited by the requirement that concealed carry license holders be 21. The greatest problems have been in determining the specific locations where bans on carrying handguns can be legally implemented. during the shooting of Dallas police officers in July 7th of 2016, described at the start of the chapter, bystanders and the police had some difficulty in distinguishing the shooter from demonstrators who were carrying long guns, but carrying a long gun in Texas has been lawful and has never been part of the debate over concealed carry, open carry, or campus carry of handguns. What is clear is that Texas handguns legislation has led to a large number of concealed carry licenses being issued. In 2017, there were 1,200,747 concealed carry license holders in Texas. Currently, some lawmakers are pushing for legislation commonly called constitutional carry, which would make the licensing process and the gun training classes optional. Supporters of the constitutional carry argue that bearing arms is a constitutional right, and the licensing and training classes burden that right. The integrity of the Texas criminal justice system. In recent years, numerous controversial issues and cases have raised questions about how criminal justices work in Texas. Here we consider whether the integrity of the criminal justice system is compromised. At the end of this section, we consider some of the reforms designed to improve the fairness of criminal justice process. How fair is the criminal justice system? Ideally, the criminal justice system should hold the guilty accountable and protect the innocent from punishment. That has not always been the case in Texas. There seem to be problems with the fairness of the system. The question is how common those abuses are and what, if anything, can be done about them. Texas is the home of more verified wrongful convictions than any other state. There is a registry that lists wrongful convictions, generally known as exonerations, in Texas and throughout the nation. From 1989 through 2019, 2,549 exonerations have occurred nationally, and 366 of those exonerations have occurred in Texas. Many of the exonerations have resulted from scientific advances in DNA technology, and a number of wrongful convictions have received widespread public attention. Randall Adams, for example, was subject of an acclaimed movie, The Thin Blue Line. Adams was sentenced to death in 1977 for the murder of a police officer. In 1989, largely as a result of the 1988 movie, Adams was released from prison. His conviction was the result of perjury, mistaken witness identification, and official misconduct. Still another widely publicized exoneration was that of Tim Cole, who was convicted in 1986 of sexual assault. Though his conviction was for one rape, he was believed to be the Texas Tech rapist, a serial rapist who had assaulted women near Texas Tech University. He was sentenced to 25 years in prison and died in prison in 1999. In 2009, he was exonerated, the first posthumous exoneration in the state, largely owing the efforts by Cole's mother and brother. Texas enacted the Timothy Cole Act, which increased compensation for exonerated persons to $80,000 per year wrongfully served in prison, and which expanded services to exonerated persons. In addition, the Timothy Cole Advisory Panel on Wrongful Convictions was created in 2009 to study the causes and prevention of wrongful convictions. In December of 2016, the panel issued an extensive final report detailing numerous recommendations on how wrongful convictions could be prevented. One of the most highly publicized exonerated cases involved Michael Morton, who was convicted of murdering his wife. On August 13, 1986, Christine Morton was beaten to death at her home in Austin. Her husband, Michael Morton, was charged with the murder and was prosecuted by Williamson County District Attorney Ken Anderson. Michael received a life sentence for the murder, though he persisted in claiming his innocence and argued that some unknown intruder must have killed his wife after he had gone to work. The day after the murder, Christine's brother had found a blood-stained blue bandana near the crime scene, and he had turned it over to detectives. In 2005, Michael asked for the DNA testing on several items, including the blue bandana. John Bradley, the district attorney at the time and known as a tough prosecutor, opposed the request for DNA testing, claiming there was no way the testing would lead to some mystery killer. He said that Michael Morton's lawyers were grasping at straws. Morton's lawyers suspected that key evidence had been withheld, and so they sought investigative materials in the case. Bradley opposed those requests as well. In 2008, Bradley was forced to turn over the investigative materials, and Morton's defense lawyers discovered that Eric Morton, who was 3 years old at the time of his mother's murder, had seen the murder and described the killer as a monster who had red gloves and a big mustache. He also had said that the killer was not his father. Defense lawyers discovered other information as well from the newly released files of the case. Police reports noted there was a check to Christine that was cashed with a forged signature after her death. There were reports of fraudulent use of her credit card after her death. There were also neighbors' statements to police that a man was seen parked in a green van near the Morton home on several occasions before the murder, contrary to legal requirement that prosecutors share exculpatory materials. This information had not been provided to the defense lawyers. Then in 2010, DNA testing on the blue bandanas was allowed. DNA was found on the bandana to belong to the victim, Christine, and to a man whose DNA was in the national database as a result of an arrest in California. The man was Mark Allen Norwood. On October 4th, 2011, Michael Morton was released from prison. He had been convicted in 1987. Mark Allen Norwood was convicted of the murder of Christine Morton on March 27, 2013. He is believed to have murdered another woman in 1988. High-profile exonerations like Morton can have political consequences. District Attorney was defeated for re-election in the Republican primary in 2012. His opponent, Williamson County Attorney Jana Duty, hammered Bradley for blocking the post-conviction DNA testing for Morton and won with a 55% of the vote. Bradley's resistance to that testing meant that Morton spent 6 additional years in prison. Judge Ken Anderson, the original district attorney, was sentenced to 10 days in jail, a $500 fine, and 500 hours of community service for criminal attempt in telling the Morton trial judge that he had no evidence favorable to Morton. He has also lost his judgeship and law license. Morton is free and will receive financial restitution from the state for the quarter century that he spent in prison for a murder he did not commit. He was present when the Texas legislature passed a bill, the Michael Morton Act, which established a uniform policy for district attorneys to make material that can help defendants' cases available to defense attorneys. Perhaps even more important than the Michael Morton Act, for the first time in Texas, a prosecutor was held criminally responsible for actions that resulted in a wrongful conviction, and another prosecutor was held accountable by the electorate for his actions that delayed Morton's efforts to prove his innocence. reforms. Despite widely publicized abuses, improvements in the Texas criminal justice system have occurred. Texas is no longer handling its crime problem solely by incarceration. The number of drug treatment programs has increased, and there is greater emphasis on imprisonment as a last response to criminal behavior, and more emphasis on alternatives such as requiring increased reporting to probation officers, community service, electronic monitoring of offenders, and mandatory treatment for alcohol and drug addiction. The result has been a decline in prison construction and even beginning of prison closings. Texas has the most generous compensation system in the nation for exonerated persons. Some police departments are modifying their procedures for obtaining eyewitness evidence. For example, the Dallas Police Department has changed the way photographic spreads for identification of suspects are conducted so that the police officer handling the photographs does not know who the actual suspect is, and thus cannot provide cues to the witness to which photo to pick. Prosecutors often call on scientific experts such as arson investigators to help prove their cases. However, fields such as arson science are rapidly evolving, and some scientific theories used to convict defendants in the past have now been debunked. Certain indicators once considered signs of arson are known to appear in accidental fires. Similarly, the Texas Forensic Science Commission has recommended that testimony that connects bite marks to a specific defendant teeth is junk science and should not be used as evidence against defendant. A new Texas law makes it much easier for an inmate to challenge a conviction if it was based on a bad science. Some Texas district attorneys have recognized the problem of wrongful conviction and have appointed prosecutors who review wrongful conviction claims and take cooperative approach toward lawyers working with their claimants. In 2016, the Harris County District Attorney announced major programs to divert first-time felony drug offenders into treatment programs rather than jail, to divert Class B theft offenders to treatment programs, and to provide treatment rather than jail for the mentally ill. These changes are a recognition that not all crimes are best handled by jailing the offenders. For the first time in Texas, prosecutors are suffering significant consequences for actions that deny rights to defendants. Michael Morton's prosecutor lost his law license and served brief jail time for his actions in the Michael Morton case, in which he failed to turn over expulsory evidence to the defense. Since then, former district attorney of Burleson County has failed in his effort to retain his law license. He had used false testimony and withheld evidence from the defense in a case where the defendant was sent to death and later exonerated. During the 2017 legislative session, one of the recommendations of the Timothy Cole Advisory Panel on Wrongful Convictions was made law. The law, the strictest in the nation regarding jailhouse informants, was in response to the recognition that one of the biggest causes of wrongful convictions was an inmate falsely testifying against another inmate in exchange for leniency in reference to his own crime. Such false testimony by inmates will become much more difficult because prosecutors will now be required to document their use of jailhouse informants, and they will have to share with the defense lawyers information about the jailhouse informants' criminal histories. Additionally, prosecutors will have to notify defense lawyers of anything offered to the jailhouse informants in exchange for their testimony. COVID-19 and criminal justice in Texas. The coronavirus pandemic created significant problems for the criminal justice system. Jails and prisons were hotspots for the coronavirus, and numerous inmates and staff at jails and prisons were stricken by the virus, and some died. That led judges and district attorneys in parts of the state to avoid jailing those accused of minor crimes by releasing them without imposing money bail. In some cities, police departments were asked to avoid making arrests for minor crimes. Focusing on crime control in the face of the pandemic, however, Governor Abbott banned the release of those accused of violent crimes or who have a record of violent crimes unless they pay money bail. In the state prison system, inmates who tested positive for COVID-19 were no longer transferred to other prisons. Additionally, the state prison system no longer accepted transfers from county jails to the state prisons. Although that practice ultimately led to greater crowding and greater COVID-19 risk in the county jails, the pandemic also caused delays in the release of thousands of inmates in the prison system who were granted parole, but who had not completed requirements prior to release, such as life skills classes or drug abuse course. As a result, jails and prisons took only limited actions in response to the coronavirus and remain major sources of infection for the disease. Criminal justice and the future of Texas. Perhaps the criminal justice systems in Texas works well overall, but is the system working as well as it should? Will Texas decide, for example, that the accused need higher quality legal representation so that problems in the system can be identified and resolved before a person is convicted and imprisoned? Former Dallas District Attorney Craig Watkins received national acclaim by offering a new perspective on his role of prosecutor, which he saw as not only convicting the guilty, but also protecting the innocent charged with crime. While Texas remains the major death penalty state and the state that holds the most offenders within its criminal justice system, its correctional policies are changing. The death penalty is imposed far less often than in the past, in large part because of a new alternative punishment of life without parole. Although politically it is here to stay, Texas is also sending fewer people to prison than in earlier years. Today, the old corrections model of lock 'em up seems to have been replaced by a more economically efficient approach in which nonviolent offenders especially are often given alternatives to prison, such as community supervision. The state is recognizing the strong connection between alcohol and drug addiction and crime, and more resources are being expanded in addiction treatment programs. The issue of the future will be whether Texas will continue pursuing alternatives to prison for offenders. Finally, many states are reducing penalties for crimes such as possessing small amounts of marijuana. Will Texas join the movement toward decriminalization? Crime and corrections have always been a major issue in Texas politics, and the state appears on the cusp of major changes in the area. This is the end of Chapter 13, Part 2.